Welcome to the Fourth Circuit's Constitution Day program. You're in for a treat because today you will hear our 3 essay winners, and they are marvelous. It is also a special treat because this year we honor the 100th anniversary of the ratification of the 19th Amendment that gave women the right to vote. 1848, 68 women and 32 men met at Seneca Falls, New York, at what would become the first Women's Rights Convention. They put together what they call a Declaration of Sentiments that followed along a lot like our Declaration of Independence. It would start a long and arduous journey toward universal suffrage, the right to vote for women. Heroines like Susan B. Anthony, Elizabeth Cady Stanton, Lucy Stone, joining abolitionists like Frederick Douglass, William Lloyd Garrison, and Sojourner Truth, led the way to the path for suffrage. And in 1920, Tennessee became the 36th state to ratify the amendment, making it the law, women's right to vote. We're so glad you're with us, and thank you for being here. And by the way, happy Constitution Day.
The Fourth Circuit Court of Appeals established its high school essay contest in 2017 as a way for students to express their own views while interacting with societal issues and legal history. The awards ceremony is traditionally held in September near the annual commemoration of Constitution Week. In 2020, the United States celebrates the 100th anniversary of the ratification of the 19th Amendment to the United States Constitution, extending the right to vote to women and expanding on the principle of equality. This commemoration guided our writing prompts for this year's contest. What barriers remain today in exercising the right to vote? What changes, if any, would you make to protect or expand voting rights? There have been numerous expansions of voting rights throughout our nation's history. From the 15th Amendment in 1870 to the 19th Amendment in 1920, to the Voting Rights Act of 1965, to the 26th Amendment in 1971. Yet barriers remain. Student essays addressed a variety of historical sources of voter suppression, disenfranchisement, and disinformation. And their essays presented ideas on remedies to ensure that the right to vote remains a vital aspect of our democracy. Please join us as we hear the essays from this year's contest winners.
May it please the court, Chief Judge Gregory, circuit judges, honored guests, and all assembled. I have the honor and privilege of introducing this year's third place winner of the Fourth Circuit Essay Contest, Justin Goldman. Joining Justin virtually today are his parents, Marietta and Ira Goldman. Justin is a senior at Maggie L. Walker Governor School in Richmond, Virginia, where his favorite subjects are government and history. He is also very involved in his community, volunteering on multiple political campaigns, playing soccer and running track and cross country, and helping run Project Engage and hosting a yearly literacy kit drive. Justin is the founder and director of Project Engage, a nationwide 501c3 nonprofit dedicated to keeping K-5 students connected and learning. Along with providing classes for students, the educational nonprofit also raises money for charities, including over $6,200 for COVID-19 relief. Every year, Justin also partners with the United Way of Richmond to bring their literacy kit drive to his school and community. He helps collect gently used or new books and school supplies, then hosts assembly events that create kits for incoming kindergarten students with the goal of improving their school readiness and literacy. Please join me in welcoming Justin Goldman.
As citizens of the United States of America, our most prized action is exercising the right to vote. To have the privilege of saying, I helped elect that candidate is a priceless feeling. Voting is how we as Americans voice our opinions and use our intellect to engage in democracy. In fact, our country boasts voting as a fundamental piece of a strong democracy. But how truly universal is this cherished activity? It seems almost contradictory to encourage such a cause when it's a futile excursion for some. Barriers to voting access, such as ID laws, polling place changes, and felon disenfranchisement, haunt the explicit rights given to all citizens in the Constitution and risk introducing moral corruption into the American democratic system. Gaining the right to vote has been the objective of many passionate and determined movements in American history. With the ratification of the 15th Amendment granting all men the ability to vote, as well as the 19th Amendment giving women the right to vote, it seemed the issue of voter suppression had been resolved. As years progressed and discriminatory policies towards minorities survived, the notion that everyone had equal rights was proved false. Through grandfather clauses, literacy tests, and poll taxes, voters of minority races were effectively blocked from a majority-dominated voting arena. While it seems that these issues were finally solved with the Voting Rights Act of 1965, other forms of voter suppression have emerged over time. One of the most prevalent barriers to voting access in the United States is voter ID laws. Legislation in some states requires eligible voters to present an acceptable form of identification to participate in an election. Currently, 34 states have enacted these strict laws, essentially negating the years of progress made towards voting equality for minorities and lower income groups. For some, it is difficult to obtain identification due to financial hardship or being incapacitated. The overall cost of applying for an ID can be anywhere from $75 to $175, according to Richard Sobel of Harvard Law School. While this may not seem like a hefty fee, for those surviving on close to minimum wage, it could be a large blow to their monthly income. It is more practical for them to purchase food rather than spend their money on travel expenses, document fees, and waiting times to receive a form of identification. In certain rural areas, the closest office to apply for a photo ID is almost 170 miles away. With public transportation often being a scarce commodity in such localities, a heavy burden is placed on those applying for a form of identification. Without direct access to mandatory IDs, capable and qualified citizens are prohibited from voicing their opinions, only further adding to the systemic racism and pervasive discrimination in our country. Commonly seen in many Black communities, polling place closures or changes bar large populations from voting in local, state, and national elections. Following the 2013 Supreme Court decision in Shelby County v. Holder, which eliminated certain provisions set forth in the Voting Rights Act of 1965, it became easier to shut down or alter the location of polling places. Decreasing the number of polling places can have a profound impact on voter turnout around the country. According to the Bipartisan Policy Center, with fewer polling places, there are longer lines and citizens have to travel further in order to vote. The lengthy wait is too much time away for work for some. Voting officials changed the precincts in order to throw the election in their favor, suppressing those of a lower socioeconomic status throughout the United States. A substantial number of felons have their voting rights restricted after being released from prison. This not only contributes to widespread disenfranchisement, but by neglecting certain citizens, it does not accurately portray the decisions of a district. Around 6.1 million US felons have been denied voting access, with 1 in every 13 African Americans disenfranchised due to their prison sentencing. While some believe that felons may contain weakened judgment by cause of their crimes, impeding the rights of these humans diminishes the idea of universal suffrage and can negatively affect civil participation in communities around the country. It is essential to regulate these pressing issues to conserve our nation's inherent principles of democracy. To expand voting rights to those who may feel excluded from American politics, multiple changes could be made. First, increased accessibility to applying for forms of identification would greatly benefit those rejected from polling places as a result of no photo ID. This would mean expanding the number of respective offices for photo ID application and also providing free resources such as no-cost application fees and stronger public transportation in rural areas. Next, regarding the closure and movement of polling locations, petitions for legislation could be enacted, requiring officials to confirm equally dispersed polling places and set mandates to limit location changes. While it's extremely difficult to push legislation into party agendas simply through advocating, it would still be useful to raise awareness for the issue. Lastly, stripping felons of their intrinsic voting rights is a problem still rampant in states across the US. While some governors have taken the preliminary steps in fixing the matter, states such as Kentucky and Iowa still fully ban felons from casting their vote in any political election. Passing legislation to prohibit voter suppression will require extensive campaigning and lobbying on the state and national level. Voting is how residents of a country express their opinions. It's the driving force that keeps the engine of democracy running and functional. Without it, the United States would be an elitist oligarchy, essentially confiscating the inherent power given to the people. The absence of barriers to voting signals a country where each and every citizen's voice is truly heard. In order to protect the foundational liberties and keep governmental power in the hands of the citizens, voter suppression must be solved and thus completely abolished. Thank you.
May it please the court, Chief Judge Gregory, circuit judges, Fourth Circuit family, and honored guests. I have the privilege of introducing the second place winner of the annual Fourth Circuit Essay Contest, Alexandra Lawrence. Joining Alexandra virtually today to celebrate this award with her are her mother, Annika Nava, and her stepfather, Dr. Andrew Nava. Welcome and glad you could join us. This is not the first time that a member of this family has participated in our essay contest. Alexandra's twin brother, Jonas, was the first place winner of our 2018 contest with his essay on the 14th Amendment and the rights of students. And yes, he has pointed out to his sister that he won first place. We are so glad Alexandra decided to enter this year's contest. A senior at Marriotts Ridge High School in Marriottsville, Maryland, she is co-captain of the mock trial team. During her freshman and sophomore years, she served as a jury volunteer with the Howard County, Maryland Teen Court Program. This program offers first-time juvenile offenders the opportunity to accept responsibility for their crimes with a true jury of their peers rendering dispositions. This experience taught her the importance of being impartial and objective as a juror, and that serving as a juror is also service to the community. Her interests include art and music. Her AP art portfolio received the highest score possible, a 5. She mostly works with oil pastels and likes surrealism. As a guitar player, she has a very broad range, playing everything from Spanish classical on an acoustic guitar to heavy metal on a Fender Stratocaster. It is my pleasure to present Alexandra Lawrence.
The right to vote is a vital part of democratic governance. Despite this, many barriers to voting exist. Legislators have enacted laws limiting access to the right to vote. Some of the most egregious examples of current voting barriers are discussed below. Given the fundamental importance of voting, these barriers to voting should be removed and the right to vote should be accessible to all eligible people. Weakening of the Voting Rights Act. The Voting Rights Act of 1965 made substantial contributions to ensuring the right to vote. For example, Section 4B provided a formula for the federal government to use in identifying jurisdictions with histories of racial discrimination. Section 5 required those jurisdictions to notify voters and to seek permission from a Justice Department or from a federal court before changing voting laws or procedures. This requirement protected minority voting rights because when a town wanted to close polling places in Black neighborhoods but keep them open in white areas, it had to seek approval in advance. In Shelby County v. Holder, the Supreme Court held that Section 4B was unconstitutional. In doing so, the court rendered the protection of Section 5 unusable. In fact, since Shelby, over 1,500 polling places in former Section 5 jurisdictions have closed. Shelby presents a barrier to voting because it gutted 2 key provisions in the Voting Rights Act that had protected minority voting rights. Voter ID laws. Many states require their citizens to show identification prior to voting. In Crawford v. Marion County Election Board, the Supreme Court held that Indiana's strict voter ID law, which required photo identification, did not violate the Constitution. However, strict voter ID laws are a barrier to voting for many, especially minorities or those with low incomes. Government-issued IDs take time and money to obtain. leading some jurists to compare such laws with unconstitutional poll taxes. Even Judge Posner, who wrote the appellate opinion for Crawford, admits the decision is widely regarded as a means of voter suppression rather than fraud prevention. Election disinformation. Moreover, the spread of false information is a common tactic used to dampen turnout among targeted groups. For example, in 2005, Oklahoma counties gave incorrect information about when former felons would be permitted to register to vote. As a result, thousands of people were deprived of the fundamental right to vote, even when they were legally entitled to exercise that right. Another example includes a current Facebook policy that refuses to deny ad space for false 2020 election information. No federal law specifically criminalizes deliberately giving false information to the public about the requirements to register or vote, or misinforming voters about polling places, locations, or the dates of elections, or the hours polling sites are open. Spreading false information to suppress voter turnout is a barrier to voting. Gerrymandering. Gerrymandering is the drawing of district lines so that one party has a greater electoral advantage. In Florida, one congressional district was 90 miles long and no more than 3 miles wide. Recently, in Rucho v. Common Clause, the Supreme Court decided that in a 5-4 opinion, the federal courts have no authority to decide controversies regarding partisan gerrymandering. The court's ruling is likely to empower an explosion of extreme partisan gerrymandering. Gerrymandering undermines a person's right to vote because it can dilute the impact of his or her vote when district lines are drawn to concentrate members of a specific group and is discriminatory when based on race. Limited access to voting by mail. Several states such as Colorado, Washington, and Hawaii routinely hold elections by mail. Mail-in ballots provide numerous advantages, such as allowing people to vote without having to take time off of work. It also allows the public to practice social distancing for health reasons during the present coronavirus pandemic. However, there is currently litigation which has sought to block emergency measures related to COVID-19, such as proactively mailing ballots to voters sheltering at home. Other lawsuits seek to ensure that every voter has access to mail-in ballots. While it is unclear how these litigations will be decided, it is clear that in-person voting during a contagious pandemic presents a barrier to voting that will need to be addressed. Ways to protect and expand voting rights. Our society must protect and expand voting rights so that voting is accessible to all eligible voters. First, the Voting Rights Act should be strengthened to protect minority voters and prevent the unnecessary closing of polling places. Second, because in the modern era, studies have debunked the notion of widespread voter fraud corrupting American elections. Voter ID requirements presents an unnecessary barrier to voting that should be abolished. Third, to combat election disinformation, it should be a crime to deliberately give false information to the public about the requirements to register or vote or the dates and times of elections. Fourth, to ensure a fair political climate in the future and to minimize gerrymandering, districts should be drawn by independent bipartisan commissions. Fifth, each district should have a reasonable number and distribution of polling places. Sixth, voting by mail should be widely available. Finally, while the right to vote is discussed several times in the Constitution does not explicitly guarantee a right to vote. This lack of an explicit guarantee has been used by the Supreme Court to refuse to decide voting cases based upon strict scrutiny, leading to the weakening of voting protections. Thus, the adoption of a constitutional amendment explicitly guaranteeing the right to vote would empower federal courts to provide strong protections to secure voting rights. Voting gives people the ability to express their views through the ballot, making it a crucial link between the people and the government. Through implementing each of these solutions, the right to vote can be strengthened and made more accessible. Thank you.
May it please the court, Chief Judge Gregory, circuit judges, honored guests, and all assembled. I have the honor and privilege of introducing the first place winner of the annual Fourth Circuit Essay Contest, Joshua Nelson, Jr. Joining Joshua virtually today are his parents, Commander Joshua and Chrissy Nelson, siblings Tessa, Jackson, and Zoe. Also viewing remotely is Joshua's English teacher, Roberta Bellissimo. As noted in the program, Joshua is a rising sophomore at the Great Bridge High School in Chesapeake, Virginia. As a member of a Coast Guard family, Joshua has lived in numerous states throughout the country, with North Carolina and Virginia being among them. Joshua is an active member in his community and church. His favorite sport is baseball, and he is a fan of the Atlanta Braves. Joshua hopes to make his high school's baseball team this spring. Without further ado, Joshua Nelson Jr.
Martin Luther King Jr. led his famous March on Washington on the 8th anniversary of Emmett Till's death. 50 years later, his son, Martin Luther King III, led another march, this one to celebrate his father's legacy and address the festering injustices of inequality, racism, and poverty in this country. Now, nearly 7 years later, in the midst of nationwide riots protesting the unjust treatment and subsequent death of George Floyd, the words of Martin Luther King III continue to resonate. The challenge of our generation is to restore the Voting Rights Act, strengthen voting rights, and broaden voter access in the legislatures of the 50 states. Congress passed the Voting Rights Act, or the VRA, in 1965, at the height of the Civil Rights Movement. The VRA prohibited Southern states from imposing racist and discriminatory voting laws. Since then, minority voters have had an opportunity to fully participate in our democracy. In fact, according to Hans von Spakovsky, a senior legal fellow of the Heritage Foundation, by 2005, the registration rate and turnout rate of Black voters was on par, and in many states exceeded that of white voters. However, in 2010, Shelby County, a white suburb located in Birmingham, Alabama, challenged the constitutionality of the VRA. Residents claimed the VRA was unconstitutional because Congress used an outdated criteria to determine which jurisdictions would be subject to the pre-clearance requirements. In 2013, during the Shelby County v. Holder case, the Supreme Court ruled in a 5-4 decision that portions of the Voting Rights Act were unconstitutional. Today, states previously covered under the VRA no longer need federal approval before enacting changes to their voting laws, and 17 states, including North Carolina, South Carolina, and Virginia, have completely reworked their election laws. For example, 2 months after the Shelby County v. Holder case overturned portions of the VRA, North Carolina passed a voting bill that implemented a strict photo ID requirement, curtailed early voting, eliminated same-day registration, restricted pre-registration, prohibited annual voter registration drives, and prevented county boards of elections from keeping polls open for an additional hour. While some of these changes might have been rejected due to the VRA, there was no longer any legislation to stop them from being passed. This is why we as a people must rally together to restore the VRA. We must propose a new coverage plan to apply to the VRA so that states will once again have their voting laws put in check. The VRA is a symbol of civil rights, and we must not let that symbol be trampled on. Advocating for voting rights is hard work, and people all over the country have been doing it for decades. Lawsuits such as the NAACP versus McCrory and NAACP versus Steen have targeted and successfully put an end to some of the discriminatory laws that restricted minorities from voting. This is a step in the right direction. Putting an end to discriminatory laws will further strengthen voting rights, and we need to do this now more than ever. According to the Federal Commission on Civil Rights, federal actions to enforce voting rights for minorities have declined sharply since the Supreme Court struck down the core of the 1965 Voting Rights Act 7 years ago. This hampers the ability of minorities to fully participate in the voting process. In America, full participation in the voting process has never come easy. The segregation is not the only reason for this. Providing reasonable access to poll stations is a continuing issue for many Americans, but particularly for urban voters. Poll stations are typically fraught with long lines and lengthy wait times that tend to discourage voters. In fact, when asked why voting can be difficult, an anonymous voter replied, "Because voting is a painful process." This past election, I stood in line for 3 hours in the rain just to vote. Another voter who spoke on the condition of anonymity stated, The churches where I vote keep closing down due to low attendance, so I'm not completely sure what voting location I'll have to go to right now. These are just some of the problems that make poll stations inconvenient. Not only do the locations of poll stations frequently change, but limited voting hours cause voters to wait in large lines for extended periods of time. Since many employers do not provide workers with time off to vote, and in many states, such as Virginia and South Carolina, do not require employers to do so, this presents a significant problem. Increasing the number of volunteers assisting at poll stations would cut down on the amount of time voters have to wait in line, and mandating that poll stations can be accessible to everyone, including minorities, will increase voter turnout. Enacting these measures will improve voter access throughout America. In conclusion, constitutional amendments have provided voting rights to all citizens, but those rights are not yet secure. In order to protect the basic right to vote, we, the people, must be willing to challenge the ideas and laws that discriminate against minorities. Martin Luther King Jr.'s March on Washington was an impetus for change, but King's dream of a society in which justice and the ability to fully participate in the democratic process, not dependent on the color of one's skin, is not yet fully realized. King dreamed that his children would one day live in a nation where they would not be judged by the color of their skin, but by the content of their character. Today, King's son, Martin Luther King III, is 62 years old, 7 years older than Emmett Till would have been had he lived, and 15 years older than George Floyd. There is still time to make the changes needed to honor the men and women who have dedicated their lives to the pursuit of equal rights. Why wait any longer? Thank you.
Justin, Alexandra, Joshua, thank you so much for your wonderful essays. Your presence and power were quite demonstrable. And as I told the audience before, and quite marvelous. You represent, as the French would say, the creme de la creme of our nation. Thank you for sharing your voice, your ideas to commemorate our Constitution with a focus on voting rights. You may notice that I put on my robe. I'm sorry that today you're not actually at the courthouse, but I want you to know that we hold these opportunities to hear from you very dearly. So I put on the full investment of our symbol of authority, because on behalf of the court, the Fourth Circuit, we thank you for your presentation. We thank you for, even in spite of these times, you were able to toil and work with passion and eloquence on these wonderful essays. So it is now my privilege on behalf of the court to present you your certificates, the beautiful words that will commemorate this day and your achievements, and give you our heartfelt congratulations and our appreciations for your scholarship. You are an indication of what our nation's future will be. As long as you continue to be engaged in the ideals of the Constitution and rights and freedoms as you have been today, we're in good hands, and we thank you for that. I also want to remind the audience that you will be ensconced in the permanent history of our court, because your names will be on the permanent plaque that displays the members of each year's essay winners. So in years to come, you can come by the Fourth Circuit Library and tell your children, grandchildren, or your friends for years to come that on this day, the rose was struck with my name and ideals of our Constitution, and to commemorate your scholarship. Oh, by the way, there's one other thing too. I have the honor of presenting you a cash award. And Justin, for your third place award-winning essay, you'll receive $1,000. Alexandra, for your award-winning essay for second place, you'll receive $1,500. And Joshua, for your award-winning essay at first place, you'll receive $2,000. Congratulations to you and your families, and best wishes for a great, great school year. Thank you so much. please stay tuned for credits that will acknowledge our essay judges and also the honorable judges of this court. Thank you so much for being with us.